Hi, everybody. This is Dan Hollander, and I'm going to spend a little time this afternoon talking about a most exciting topic, the titling of property. So what is titling? The titling is basically the means by which you declare and designate ownership of the property, whether it be your home, whether it be a trust account, any type of investment, anything that you'd want to be able to delineate as something that you own and do not want or need a probate court to decide upon and to direct. So why is that important? In the past, I've talked about estate planning documents, having a will, oftentimes a pour-over will, which allows you to pour over into a trust if you've forgotten to title it. But the key is if you have trust documents, if you have a will that are expressing where you want your property to go upon death. This is well transferred to whom, when, how you want the property to be distributed. You have to be able to direct it with money that's been funded. The only way you fund your legal documents is through proper titling. So let's go through a few examples. If you have a investment account and you have a living trust, then you should have the proper name of the trust owning that investment account. So if in my case, it's the Daniel S. Hollander Revocable Living Trust, and I have a date on it, so under the date, then you list the trust as such. That's funded so that the investment account lists that trust as the owner of the investment account and me, in this instance, as the trustee. I control. Similarly, if you have a joint account, and many people do, husband and wife at a bank, you want to have it titled properly at the bank. So here's an area that you might want to then reflect on. Is a joint account the best way to title a bank account if you have a trust? Is the trust funded when you have a joint account? The answer is no. So where is the problem? The problem lies is that if there's a common disaster, husband and wife, they often drive together. If they get snuffed out in a car accident, the reality is that money goes to probate court. It doesn't just go down to your kids. So some people say, well, okay, I'll just put our kids on our joint account at the bank and we'll have 6 of us on the account. That's not a good idea, because if you title that way, you're just asking for trouble in that you're jointly owning an account where you've got 4 children that may represent additional liability risk if one of them gets into an auto accident and that auto accident exceeds their property casualty auto insurance limits. Now they can attach this a joint account as well in a lawsuit where creditors are having to be paid. So what is the solution? One solution is obviously changing the joint account to a trust account. Another, because oftentimes spouse want to have a joint checking account, and sometimes they leave a fair amount of money in it. And the solution there is to ask your banker whether they have what's called a TOD form, a transfer on death designation form. And normally you'd see one in larger banking institutions for both individuals and for spouse, so that they're jointly held. So now you can have what is a surrogate beneficiary designation. You have a joint account, but if there's a common disaster, then what results is that that designee, your trust as an example, is now the beneficiary of that account. And then everything that you've created, all the instructions you provided within that trust document control. Let's talk about another example. Should you have your home titled to a trust? The answer is maybe yes, maybe no. The trust obviously is always effective in terms of directing the assets to the beneficiaries, the intended beneficiaries. So if you have a husband and wife, once again, I'll use the common disaster scenario, a real pathetic and horrible hypothetical to use, but that's the reality of it. We're trying to stretch our imaginations to what could happen. And in that case, the trust would direct it to the ultimate beneficiaries, and perhaps would be the children. And they could sell the house and divvy up the proceeds. But the question then is that the most efficient way to do it? Is it also addressing other issues like liability exposure? So in the state of Michigan, now we could address other states for those people that are coming to our video blog outside of the state of Michigan. But in the state of Michigan, there's a special type of tenancy, joint tenancy, called tenancy by the entireties. Tenancy by the entireties is a type of joint ownership between married couples. And if you have tenancy by the entirety, and your house is set up with that type of titling, it is insulated. It is protected from creditors, so that if there's a lawsuit, they cannot attach your home. So oftentimes attorneys will recommend that your home remain jointly held if you are married, so that the tenancy by the entirety's protection controls. If, on the other hand, you simply want to be able to have the trust, then you proceed in that way. But the titling should not be in an individual's name, and the risk of having the tenancy set up just by two individuals, as I said earlier, it could ultimately go to probate court. So 1, you want to be able to avoid probate court. 2, you want to mitigate taxes. 3, you want to have creditor protection as much as one can create. And 4, you want to be able to instruct a trustee or a executor. In Michigan, we refer to a personal representative, as to where you want your property to go and when you want the beneficiaries to receive the property. And that can be controlled by the trust. But as I said, unless that trust document, through the various assets that you title to it, unless the proper titling is created, the trust is an empty shell. It's worthless. So make sure that you sit down with your advisor. If you're our client, sit down with us. You probably have already done so if you are our client. And make sure we're dotting the I's and crossing the T's to not only making sure wealth transfer is efficiently set up through proper legal documents, but that these documents are meaningful because you have funded the documents through proper titling and beneficiary designations. I think I'll stop there today because it does get complex. Maybe I'll throw in one other thing. If you have an IRA, many people ask, well, how should we be setting up the beneficiary designations? How should we have a beneficiary designation of our 401k? Well, that's in some ways a form of titling, because you're directing through a beneficiary designation, much like the TOD, the transfer on death designation that we spoke about with regard to a bank. And the beneficiary designation should have, if it's a qualified account, qualified for tax deferral, a 401k, a profit sharing, a 403b plan, an IRA, a Roth IRA. They should have the spouse listed as the primary beneficiary, and then the owner's trust as the contingent. That's what most attorneys will recommend for the proper flow, the proper designation, coupled with other titling of assets, so that the money that you've worked hard to save, the home that you've worked hard to purchase and maintain, the various accounts that you maintain will be able to go to the proper parties, and that the trust documents that instruct the trustee and or ultimately a judge, if there is no successor trustee, will understand what you want and make sure that it's properly designated and that the beneficiaries are taken care of. Look forward to speaking to you again. Have a good one. Take care. Bye-bye.